There's a recent Fair Work Commission decision that's drawing a lot of attention around corporate Australia, and that's the decision of Karlene Chandler and Westpac Banking Corporation. So in this matter, the Commission has had to take a look at both the procedural and substantive requirements of responding to a flexible work arrangement request under the Fair Work Act. The Commission has had to make a decision about the force of that type of a request, and has had to consider how, although requesting a flexible work arrangement is a workplace right, the way that an employer responds to that needs to be balanced with that employer's genuine business needs.
Yeah. So in this case, what had happened is Karlene Chandler was a long-term Westpac employee that had been working remotely for several years before this case. When Westpac reintroduced its hybrid working policy and requested that employees return to the office at least 2 days per week, Karlene made a flexible work request that she be allowed to work permanently from home, and cited her care responsibilities for her 2 school-aged children.
That point about her family responsibilities is really key here. So she's made the request under Section 65 of the Fair Work Act, which allows employees to make this type of request for various reasons, which include disability, family responsibilities, and a number of other things.
So it's just specific classes of employees that can actually have the right to make these sort of requests.
That's right. And then Section 65A looks at how an employer must respond to those requests. So employers, once they receive a request like this, they need to do 3 things. They need to genuinely consult with an employee. They need to consider how the request might impact the employee and also the workplace. And they need to provide their written response to the request within 21 days.
Yeah, so in Karlene's case, what the Commission found when she challenged the decision was that there wasn't any genuine or papered consultation process, that there was very vague citations of collaboration and team culture as the business need to deny her request, but they didn't provide any documented business case. But it was just general assertions, very vague assertions in their response. And they didn't respond within that 21-day time period. So ultimately, the Commission found that her request was reasonable, and they did grant her request for a permanent, flexible work from home arrangement.
So if an employer does decide to refuse a request like this, they need to consider the reasonable business grounds upon which they can refuse that request. And those reasonable business grounds can include things like cost and operational efficiency. They need to be considered within the context of that employee's particular work arrangement. So in this situation, Ms. Chandler's role had already been performed remotely for quite a long time.
Yeah.
And there was no considerable impact that remote work performance had on Westpac, and that was a key factor that the Fair Work Commission considered in this matter.
So the absence of any performance issues in the temporary arrangement that had been granted was an interesting part. And what I've seen following this decision is a lot of debate about what this means for temporary flexible work requests moving forward. There's some employers or individuals who think that now employers will be less inclined to grant temporary work arrangements that they otherwise might have done, for the fear that if they can show, or if the employee can show that it doesn't impact their role, they might be forced to accept a permanent arrangement. What do you think about that?
I think that's a really valid concern, because the Commission did essentially emphasise that because she'd been working remotely for a number of years on a somewhat temporary basis, that kind of set a precedent for how the Commission responded in this matter. But on the other hand, this could create a situation where employers feel obliged to simply accept any work from home request that's made by employees on the fear that refusing that could expose them to litigation and a public outcome like this one.
Yeah, and it's not so much about the fact that, you know, in this specific case, it was a precedent for this sort of work. It was the other failures, the failure to respond within that time frame, the failure to actually identify if there's an issue about collaboration or team culture, how does that actually affect Karlene's specific role? So it's not that it gives free rein for all employers to just be able to say, you know, no and move forward. It's about the specific failures here.
That's right. So the procedural failures of Westpac in this situation were, you know, just as important as the substantive response that they gave. And the Commission did consider both of those. And ultimately Westpac faced criticism for both of those areas.
Okay. So if you're advising an employer in this sort of situation, what are the 3 things that they must do to avoid this very situation from happening?
Well, the really key thing here is to actually be aware of the law and of the requirements under the law.
Yeah.
Now, the Fair Work Act is notorious for having really strict timeframes. The next thing is to actually be conscious of what is in their response. So an employer needs to make sure that they have consulted with the employee, they've considered the reasonable grounds upon which they could refuse or accept the request. And they've also considered how the refusal might impact that employee. And so they need to make sure that that is all considered within their response, and then that response is provided within that 21-day time frame.
Yeah. So to wrap up, it's document the consultation process, ensure that response is given within 21 days, and ensure that response, if it is a refusal, articulates the specific business grounds for the refusal.
Yeah, so they're really the main things that employers need to look at here, and just making sure that they're responding appropriately. Now, it will be interesting to see whether this matter prompts any future matters about the same issue, or whether this really changes the overall sort of scope of working from home in Australia.
But interesting to see maybe a few more flexible work requests.
Yeah.